Our MC for this press conference will be Mary Kay Rogers, 2004 Pennsylvania Green candidate for State Attorney General and 2006 candidate for Governor of Pennsylvania.
Thank you, Scott. As many people here know, when I ran for governor in 2006, our ballot access laws in Pennsylvania required what we considered to be an impossible number of signatures to gather, and at that time I filed federal suit against the Commonwealth of Pennsylvania because of the third-party signature requirement. That case is still in process. We've applied to be heard by the Supreme Court of the United States, and we're waiting for October to know if we'll be heard or not. I was also originally one of the defendants in the lawsuit of the Democratic Party against Nader Romanelli. I withdrew from that because of my concern about the ballot access lawsuit and continuing with that. Mr. Romanelli continued and fought the good fight with the state lawsuit, and he'll have more words on that shortly. I'd like to mention we have one person here who is not scheduled to speak but may be able to answer some questions. We have a distinguished guest from Canada, Dr. Janet Eaton, who is the Green Party of Canada's international trade critic. And if you'd like to just give a wave so that people can see where you are, Janet.
Cool.
Our first speaker, who I have the pleasure of introducing, is Phil Huckleberry. He's the co-chair of the Green Party of the United States Ballot Access Committee, a member of the Illinois Green Party, and he ran the most recent petition drive in the state of Illinois, which he would like to tell you about. Phil?
Hi, my name is Phil Huckleberry. I live in Chicago, Illinois, and I am co-chair of the Ballot Access Committee of the Green Party of the United States. First, I want to talk very briefly about what the National Green Party is doing in terms of preparation for 2008. What we are talking about right now, which is something that we have not talked about in the past, but largely because of the circumstances in Pennsylvania, is having the National Party make a top priority, the number one priority, securing ballot access in all 51 states, that includes the District of Columbia, in 2008 for our eventual presidential and vice presidential candidates. This is a priority that we have not made at the same commitment level in the past, but we are gearing up for that in part because we know, based on what has happened in 2004 and what has happened in 2006, that the obstacles which we're facing are growing, and we know that we can out-organize many of those obstacles thanks in part to experiences that we've had, such as the experience we had in Illinois in 2006. Illinois, like Pennsylvania, is what's called a challenge state. When you turn in your petition signatures, they are subject to, instead of review from a state board of elections or a Secretary of State's office, they're subject to challenge from some other resident of the state. We turned in 39,300 signatures collected in 90 days in Illinois, and the Democratic Party used a couple of operatives working on behalf of the Democratic governor of Illinois, and they claimed that 26,000 of our signatures were invalid. This is nothing new in Illinois. Illinois has an extremely bad reputation for this kind of corruption. What was new is the strategy that we used to counteract what we were dealing with. We took our 39,300 signatures and we sat down, and as a unit we transcribed all of this data, we ran it against the state voter rolls, and we were able to walk into the State Board of Elections hearings instead of having to prove using the voter data there that we had valid signatures. We were able to walk in with voter identification numbers and additional information to demonstrate that the Democratic challenge was made in bad faith. We know that the Democratic challenge in Pennsylvania was a very similar bad faith kind of challenge, but next time around, if there is a next time around, we're going to apply everything that we've learned in Illinois and everything that we've learned through similar efforts across the country, and we're going to make sure that we are prepared and we will out-organize whatever we need to out-organize to make sure that we can run the strongest possible candidacy, not just for president in 2008, but for offices above and beyond that. Because we know that the main issues, many of the main issues that we're running on, things like election reform, things like trying to restore basic democratic rights, these are just bedrock institution principles of the Green Party. We have a long track record of this. You can look at what we've been doing on ballot access for a long time. You can look at the 2004 election and the efforts of our candidate in that year, David Cobb, with the Ohio and the New Mexico ballot recount, because we know that our election system is largely bought and sold in America, and we're the party that has made the most profound statement to try and go out and do something about it. And we're going to muster everything that we've used in the past. We're going to apply it to future challenges, and we believe that we'll be very successful doing that. Thank you very much.
Ladies and gentlemen, I'd like to next introduce another Pennsylvania Green, Titus North, who, aside from being a professor, is also the 2005 Green Party candidate for the mayor of Pittsburgh, and in 2006 ran for the 14th Congressional District in the Allegheny County area. And Mr. North was, like Mr. Romanelli, also the subject of a major ballot challenge.
Thank you. Yes, I'm Titus North. My petitions were also challenged. They were challenged at the same time as Mr. Romanelli's, and in fact, my petitions all had Mr. Romanelli's name on them as part of the process in petitioning in Pennsylvania. Now, the fact that my petitions were challenged shows that the whining by the Democrats about throwing elections to the Republicans or raising Republican money or using paid petitioners or other complaints that we heard at the time with regards to Mr. Romanelli's campaign or with regards to Ralph Nader's campaign in 2004, that was all nonsense. There was no Republican in my race. It was a two-person race, myself and the incumbent Democrat. What little money I raised came from genuine supporters, and I paid no petitioners. The fact that the Democrats challenged my petitions demonstrates that their true motive was to destroy the Green Party and deprive voters of genuine anti-war candidates, leaving voters with no option other than pro-war, pro-corporate Democrats and Republicans. Also, I was deeply involved in the petition drives both for the Nader 2004 campaign and the Romanelli 2006 campaign, personally collecting thousands of signatures, organizing volunteers, handling petitions, verifying signatures, and attending court proceedings. So I feel uniquely qualified to compare the relative validity of the Nader and Romanelli signatures with the North signatures, which the Democrats had to concede had a high validity ratio, and that the courts maintained my position on the ballot. There was no significant difference in the signatures. There's no significant difference in the validity of the signatures. The reason that I stayed on the ballot was that our task was compact enough that my dedicated volunteers were not overwhelmed by the deep pockets of the Democrats. Not that we had great resources, but my volunteers put up a tent in a campsite outside Harrisburg, and we stayed for free or for $12 a night. In this way, we weren't overwhelmed by the high-priced lawyers and their efforts to try to wear us down. Now, when I say compact, I mean that my volunteers were familiar with the street names in my district. The district is small geographically. And because they were familiar with street names, they were more successful in deciphering the handwritten information on the petitions, which is always difficult to read. This allowed us to protect more bogusly challenged signatures than the other campaigns were able to. What I want to emphasize is that the only fraud that took place in 2004 and 2006 was the fraudulent disenfranchisement of tens of thousands of Pennsylvanians by the Democrat Party and their high-paid lawyers. Thank you very much.
Before I introduce our next speaker, I would also like to acknowledge the presence of Clifford Thornton here. Clifford, could you give a wave? He's there in the back. Clifford Thornton is the 2006 Green Party candidate for the governor of Connecticut. Welcome, welcome. It's great to have you here.
Thank you for having me.
The next person I would like to introduce is a very, very good friend of mine. He was a good friend before. We are closer now that we've been in the trenches together. Ladies and gentlemen, Carl Romanelli was the 2006 candidate for United States Senate for the Green Party of Pennsylvania. He was the subject of Democrat Party attack from the day he announced, because even though he provided the only true alternative to Senator Rick Santorum, he was lambasted as nothing more than a spoiler. Spoiler is a term that I think we can only say, if it's good enough for Ralph Nader, it's good enough for us. But considering that the Democratic candidate happens to be pro-war and anti-choice, two phrases frequently applied to Rick Santorum, Carl was indeed the only viable alternative, and we have none in this, and we have a second senator in the state who has the same platform as the last one, unfortunately, thanks to the Democrats to keep Carl off the ballot. Ladies and gentlemen, a real hero of mine and a good personal friend, Carl Romanelli.
Thank you very much for coming, Greens, and especially the media. Before I talk about the case itself, I just want to acknowledge some of the people in Pennsylvania that have helped us throughout this struggle. First and foremost, a heartfelt thank you to Attorney Larry Otto, who it was sometime back in September when I last gave him any kind of money. He was more than 9 weeks pinned down in Harrisburg working on this case around the clock, additional work on weekends and in appeals. So his support it can't be underestimated in any way. The Green Party of Pennsylvania, especially certain individuals. Titus made reference to that camp that was set up in Pittsburgh, but he was very, or in Harrisburg, by the Pittsburgh folks who were helping us. But he's been very modest, because after Titus's challenge was over, many people from Pittsburgh stayed and were kind of the glue helping to keep that insane situation room together. The United States Green Party, I would like to thank. I was very bold in taking the spoiler argument and the stinking corruption of this political system and what it inspires in people. And that boldness, by taking money from someone who was normally our enemies, brought our party under a lot of undue heat. And I think a lot of it is because we really didn't get a fair shot from the media. Because despite having a candidate for the United States Senate who was willing to answer any of your questions about who I am, about what our issue positions are, and about what I did to get the money, because I thought of it, I executed it, and I did it. And I did that for a very important reason. First and foremost, as the United States Senate candidate, I was the top of the ticket. It was my responsibility to make sure that I was part of the organization that assured that we got on the ballot. The requirement in Pennsylvania was the highest ever despite how restrictive this state is, what we were required to get in 2006 was double of what Ralph Nader was required to get 2 years earlier. We did not have the means to do that on our own. But by being able to pay people around this state in order to make sure that that job got done. And Titus mentioned they didn't use paid petitioners, and the Greens almost never do. But this year we needed to. And there's nothing wrong with that. It's done all the time. There are legitimate legal businesses which dedicate themselves to this process alone. But it was the least recognized of our Pennsylvanians who stepped up for us, because it was not only members of this small party, it was senior citizens, college students, poor people, working people, minorities from around this state. They're the people who stepped up and got us on the ballot. And I see nothing wrong with what we have done for 7 years in Pennsylvania. We have lobbied our legislature to change these oppressive laws. They laugh at us and say, hey, if you're not big enough to compete and can't play the game, I guess you don't belong here. We went to the courts on a number of different issues. And the court's constant answer is, well, yeah, it's different, but it's not unfair. It's done like that. There's oppressive laws in other states besides Pennsylvania. So the courts would not protect us. The legislature would not respond to us. Our citizenry doesn't care, and the media continues to define all politics from the paradigm of two. We are a nation of 300 million people. You're telling me you can't count to 3 or 4? Okay, and even if there was some legitimacy to this absurd idea that the courts must protect us from ballot clutter, well, I was the only clutter for any statewide race of any party or no party in the game. So even that argument goes out the window. Now, I knew getting into this as an operative for years for the Democratic Party because of my concern 30 years ago about the Democratic Party shift to the right and the fact that they were becoming indistinguishable in contributor and in policy and in double talk to the Republicans. We tried to reform the Democratic Party from within, but it was resistant to it, continuing to stack the deck. So we have had to organize on our own, but believe me, with that many years in politics, I didn't expect this to be pretty. I knew what the Democrats would do to us. But what was not acknowledged, and what must be acknowledged, and where we are demanding the media to pay attention, is the reprehensible behavior on the part of the courts with regard to ballot access issues. This has been a concern that has, in fact, gotten worse over the years. I believe we're getting another visitor. Is Mr. Nader here?
In 1 minute.
Okay. So, to make a long story short, there was nothing wrong with our signatures. Our process had integrity. We took great care. We random sampled our pages. We got our notaries to the scene. We filed a package that was tight, that was concise, that was legal, and that showed respect for the state and the court. After 9 weeks, do you know that a judge never looked at any of these signatures? We saw the stories all over the media about how my signatures were supposed to be wrought with fraud. Names like Mickey Mouse and Mona Lisa and Robert Redford, we will not tolerate that. Well, out of 95,455 signatures, 95,455 signatures that we actually filed, the Democrats could only name 52 that fit that category. Of those 52, half of them were in fact rehabilitated and were legitimate voters, including Robert Redford and George Bush from Philadelphia. And just for the record, there was never a Mickey Mouse who signed my petitions, but there is a Michael Mickey Mouse who is a registered voter in Franklin County, Pennsylvania. 100,000 signatures is more than any candidate in the history of this Commonwealth has ever filed. It was 30% more than the amount that we needed. States that commonly file 100,000 signatures for candidates are states like California. California has 59 million people. Okay. Okay. Okay, but the announcement today is that it is my intention to report Judge Collins from the Pennsylvania Commonwealth Court and Judge Kelly, Senior Judge of the Pennsylvania Commonwealth Court, to the Judicial Conduct Review Board of Pennsylvania. Their partisan behavior in both the Nader case and in our case is reprehensible, and the courts must be held accountable for this hijacking. Again, the court should not be the agent of any political party, but rather the bedrock protection of its citizenry. Further, the press has been very resistant to write about the latest twist in this case, in that in addition to fining me, as my friend Ralph Nader has been fined, they have also seen fit to fine my attorney with the same costs, figuring that I might be too poor to pay it, so now we're going to go after the lawyers. What is going on in a judicial system where a lawyer representing someone attempting to defend themselves is somehow subject to the same penalty? It's a good thing the judges didn't sentence me to death. This needs to be done, and this is the story of this case. The reprehensible behavior of the court, and we are not going to let that rest, and that this was all done on the part of the Democratic Party. This illusion that the Democrats are the good guys, or they are going to somehow save us from the same people they acquiesced to for the past 7 years, is inane. I'm not buying it, and though I'm small, I am not weak, and I am not finished, and I promise you, my friends, we will prevail.
Just briefly, Mr. Nader is here. My name is Carl Mayer. I'm an attorney that was involved in the litigation over the campaign. Just for some reference to Pennsylvania's, I'm from New Jersey. In New Jersey, it takes 1,000 signatures for a candidate to get on the ballot for the presidential election. It's rare in American politics that New Jersey is held up as a model of democratic inclusion. However, in this instance, it shows that even in states like New Jersey, you can write rules that are fair. Even with the 1,000 signature requirement, the corporate law firm hired by the Democrats tried to challenge it. They lost. We prevailed. But that stands in sharp contrast to how draconian the rules are in the state of Pennsylvania. I want to just give it over briefly to Bruce Affron, who's one of the key attorneys in fighting ballot access, which seems to now be a permanent fight between the two parties that are erecting these monopoly barriers and any other party that wants to advance an agenda before the American public, which is somewhat of an irony given that now 2/3 of the nation expresses disapproval of the executive, and 75% is now expressing disapproval of the legislative branch. So Bruce, why don't you come up and say some things.
Thank you, Carl. Good afternoon. Good evening. I'm Bruce Affron. I'm one of the attorneys who represented the Nader 2004 campaign in terms of its ballot access cases. And as you know, there were ballot access cases all over the country. The Nader campaign in 2000 received nearly 3 million votes in the general election. In 2004, the Nader campaign was kept off the ballot in nearly every large state, including Texas, Arizona, North Carolina, Virginia, California, Washington, Pennsylvania, and Ohio, and others. With the result that the campaign was denied at least 2 million of those 3 million votes that it had received in the 2000 election. This did not happen because of the choice of the American voter. It happened because of the actions of judges at the behest of Democratic Party officials in the various states who engaged in a concerted campaign. I think a conspiracy is probably the word Mr. Nader would use, to keep the Nader campaign off the ballot. Never in American history has a major party ever attempted to destroy its competition on the ballot through the court system. What happened in the 2004 campaign, as demonstrated in an immense degree in Pennsylvania, was a perversion of election law, designed not to protect voters' rights or to foster voter choice, but to reduce that choice through the use of law at the behest of one political party. Now, I think we can contrast this behavior in a certain way to the Republicans when they were faced with 2 successive campaigns by Ross Perot. In neither of those campaigns, despite the fact that Bill Clinton arguably was elected by Republican votes going to the Perot campaign, did the Republicans attempt to destroy a third-party campaign. Ross Perot was not challenged by the Republican Party in either the 92 or the 96 election. The Democrats in 2004 used every legal resource, not lawful, but resources in terms of legal personnel that they could muster to destroy the Nader campaign. Ralph Nader is here today in connection with the Green Party convention, and I'll introduce him in one moment to discuss in particular ballot access problems in Pennsylvania. I want to discuss for a moment, if I can, the result of the case in Pennsylvania that resulted, 1, in the destruction of the Nader campaign's ballot place, and 2, an immense judgment that is now equal to $100,000 against Ralph Nader personally, in the same manner as Mr. Romanelli spoke of a few minutes ago. Pennsylvania law required 25,697 signatures for a candidate to be on the presidential ballot in 2004. The Nader campaign submitted 51,273 signatures, twice the required amount. Now bear in mind, this is generally done through paid circulators. It is an enormous expense, and it is immensely difficult to accomplish. The Nader campaign secured twice the required signatures. Through a series of court actions in 12 different courts in Pennsylvania, which the Democratic Party could easily finance, but the Nader campaign could not. Imagine a third-party campaign finding counsel to appear simultaneously in 12 different common plea courts in the state. Clearly the Democrats can do that, since they've got a horde of lawyers who are desperate for patronage, who will volunteer in many cases their services in each county in the state. A third-party campaign can't do that. Pennsylvania courts were used to prevent the Nader campaign from effectively defending its position in that election. One thing Mr. Nader will speak on are reforms for Pennsylvania law, including creating a statewide nonpartisan ballot review commission. Now in New Jersey, our neighboring state just a short distance away across the river, as Carl said, only 1,000 signatures are required. But of even more importance, there is a single statewide office where a challenge is made. A campaign need appear at one location at one time to deal with challenges, not 12 or 13 locations throughout the state, which bankrupts and destroys an independent or third-party campaign. Now remember, out of the 25,697 signatures required, the courts ultimately found only a valid number of 18,818 signatures, which according to the ruling meant the campaign fell short by about 7,000 signatures. However, of these disqualified signatures, 8,000 were disqualified not because the voter was not registered, and not because the information was incorrect, but because someone else had written in the voter's address, and that the handwriting differed from the signature. The address was correct in each case, the voter was a registered voter, and the voter had signed the petition. Yet because Pennsylvania law technically requires that the voter fill out every line in his own handwriting, 8,000 valid signatures were thrown out. In addition, 2,000 were thrown out because small bits of information, such as zip codes, were not included. Now, obviously, many people who fill out petitions are elderly and need help completing these documents. That's all that took place. Yet 8,000 signatures were thrown out for no other reason than the handwriting of the address was not the signatures. When you add in these 10,000 signatures, which should have been counted in any system of law, the Nader campaign had 28,818 signatures, far more than was needed to remain on the ballot in Pennsylvania. Now, in the face of this, President Judge Collins described the Nader campaign as engaging, well, the signature process in the campaign, as, quote, the most deceitful and fraudulent exercise ever perpetrated upon this court. Yet, the Supreme Court identified a total of 687 signatures out of 51,273 that were fraudulent, that were forged. Every other signature was a valid signature by a voter who put it on that paper. So the notion that the media has accepted, unfortunately, and the notion that has been placed in the court record that there was a fraudulent and deceitful process in this campaign is simply false. This campaign admirably acquired the correct number of signatures and met Pennsylvania's immensely difficult and onerous and arbitrary signature requirements. Now, just across the river, only 1,000 signatures are needed. And in New Jersey, Ralph Nader appeared on the ballot, along with several other independent candidates. In Pennsylvania, voters were not given the chance to vote for Ralph Nader. Now, one has to consider whether Pennsylvania voters have been the victim of a deceitful and fraudulent campaign. And quite frankly, the courts of Pennsylvania, with the exception of Justice Saylor, accepted this hook, line, and sinker. The result of that election was the imposition of an $80,000 penalty for costs of court transcripts and handwriting witnesses' fees that the Nader campaign was required to pay. Actually, the Ralph Nader has been ordered to pay. I'll close with this comment. This amounts to a bankrupting penalty upon any independent challenger who seeks to be on the ballot in Pennsylvania. As Mr. Romanelli said very clearly, this has a chilling effect on the willingness of people to run for office in this state. And it is not only independent candidates. Primary challengers who challenge an endorsed candidate of the political party will also be subject to this penalty in the future. And the political system in Pennsylvania needs to recognize what it has unleashed. It has unleashed a chilling monster of bankrupting penalties that will destroy political diversity in this state. In the entire jurisprudence of the 20th century, no American court has ever done what the Pennsylvania court did to Ralph Nader and Mr. Romanelli. I'm reminded of Singapore, where the government repeatedly uses libel cases to bankrupt political opponents who simply criticize government policy. In the same manner that Pennsylvania has done to these two campaigns, the Singapore courts repeatedly bankrupt their opponents with libel for merely criticizing government policy. That is where Pennsylvania is headed, unless this can change. I'll now call upon Ralph Nader to discuss this in detail and with the passion that I know he brings to it.
Thank you very much, Bruce, Carl Romanelli. And thank you all for coming. This issue now transcends the various subjects of injustice that third parties, independent candidates, usually take on. Unlike any other Western democracy, no other country comes close to providing voters with such small number of choices and to making third-party independent candidates hurdle an almost insuperable series of obstacles just to get on the ballot. Norway has 7 or 8 parties. Chile has 9 parties. Germany has numerous parties. Canada has 5 viable parties. They have debates. It's very easy to get on the ballot in those countries. They're not afraid of new voices and choices. But in this country, if you run for federal office, whether it's the presidency, the vice presidency, or Congress, you have to adhere to a variety of laws that are interpreted by partisan judges, that can be invoked by well-heeled opponents. And if you run for president or vice president, you have to deal with 50 different state laws that range from modest hurdles to get over, as in New Jersey, to draconian numbers of signatures. North Carolina comes in with over 100,000, for example. You have to usually get twice the number of the statutory required number of signatures. That's only the beginning, however. Sometimes there are county differences. Very often there are differences as to who can walk the streets with a clipboard. In Arizona, for example, you have to be a resident of Arizona. You cannot call on Texas friends to come over the border and get signatures for a presidential candidate. In other states, there are restrictions as to whether anyone can sign your petition on the streets if they had voted in a primary. In Texas, anyone who votes in a Texas primary is prohibited from providing a verified signature for another candidate with a clipboard. So if that person does sign, it is disqualified by any opponent that wants to challenge it. Now, Pennsylvania is now the King Kong of ballot access busters among the 50 states. There's nobody now that can challenge the King Kong title of Pennsylvania, the state that has a city called the City of Brotherly Love. Philadelphia is now the center of a judicially implemented strategy that can just about knock off any third-party independent candidate if one of the two parties really wants to go all out to do so. Imagine receiving a call in Washington and being told that we had to have attorneys in 13 different courtrooms at the same time Monday morning in the state of Pennsylvania to go over the various signatures with the objectors and the judge. To call this archaic, I'm reminded of what Benjamin Franklin would have thought rather of something like this. If it wasn't so tragic, it would be high-level comedy. That we're dealing here with the political bigotry of the first order. It's now generally recognized that it's bad form and unconstitutional to deny voters their right to vote on the basis of their race or their income or their gender or their religion. But for some reason, we have not reached that level of judicial tolerance and affirmation when it comes to candidates' rights to get on the ballot. Now, without voter rights, candidates' rights aren't worth much. And without candidates' rights, voter rights are not worth much. They both nourish each other in a more robust, diverse, multiple-choice democratic process. Now, when the Soviet Union was in operation, we would be told by the Soviets that 98% of the people in the Soviet Union voted in an election. And everybody in the U.S. would laugh. Not because they doubted the 98%, but because they knew there was only one candidate on the ballot. And in more districts in our country, local, state, and national, there's only one effective candidate. Either there's no candidate at all on the ballot to oppose the incumbent, or it's a nominal candidate by the opposing party, sure to lose, just as a matter of presence. There are 40% of state legislatures and legislators in our country run without anybody opposing them on the ballot. In some states, like Massachusetts, it's 60%. So we start out with a one-party dominated political system that's getting worse with gerrymandering and with the ability of one party or another to basically marginalize the other party from the get-go. And then when you try to break this up a bit with a little more diversity, you see where the ballot access barriers kick in. Now, I wrote my first article on ballot access barriers against third-party candidates in 1959. So I'm not a newcomer to this issue. And in going back and rereading it, it is an understatement of what is occurring today. In other words, it's gotten worse. Here in Pennsylvania, to further complicate the political bigotry and to further the parochial and bigoted objectives of the Democratic Party, the judges in Philadelphia clearly misinterpreted Pennsylvania law in the following areas. They disqualified thousands of our signatures on the grounds that the voters who signed our petitions were not registered at the time. As Justice Saylor pointed out, there is no requirement in Pennsylvania law that voters 18 years and older who are eligible to vote are required to be registered before they can sign a candidate's petition to get on the ballot. The second area that was misread by the judges was that the address given by the voter signing the petition was different than the address that the voter gave when he or she registered days, months, years earlier. There is no requirement in Pennsylvania law that that address on the street has to be the same as the address that the voter filed when he or she registered. People move. And apparently if they move, they get disqualified in Pennsylvania from signing a petition. There are 3,200 signatures that were dismissed for no reason whatsoever. So this is clearly a corrupt system. This is clearly an unconstitutional system, regardless of what the majority of the Supreme Court of Pennsylvania decided, because they didn't do their homework, because they don't like these kinds of candidate access cases, because they think this is a two-party country, as does Justice Scalia. Whatever their motivations, a first-year law student wouldn't have made the legal error that Judge Collins made, affirmed by a majority opinion on the first round by the Supreme Court of Pennsylvania, without even an opinion, and affirmed on the second round with an opinion that was torn to bits by Justice Saylor, who actually does believe in reading the law. He does believe in free and equitable treatment of candidates running for office, who does believe that the voters of Pennsylvania deserve more voices and choices, and the access to the ballot should not impede that objective, and who does believe that throwing people off the ballot in such spurious manner is basically denying voters their right to vote for candidates of their choice. So what do we do about this? Well, the first thing we have to do is generate a level of public indignation that is lacking now. It's lacking because the two parties don't mind the system. It's lacking because there is a lot of misunderstanding of the system. And it's lacking because of the fraudulent and deceitful language against the Nader campaign by Judge Collins, paraded all over the state again and again and again through the media. Judge Collins, if he's capable of it, should be ashamed of himself. Even though he is elected as a Democrat, even though he's part of the Democratic machine, even though he has associates very, very heavily embedded in the Democratic Party from many years back, we still expect of Judge Collins an elementary level of recognition of what the plain wording of the Pennsylvania statute is, and judge that accordingly. He received a severe tutorial from Justice Saylor, but it didn't seem to affect him at all on the first round. He was confronted by Reed Smith, which is one of the 15 largest law firms in the world, representing, among others, an assortment of giant pharmaceutical companies, John Kerry, Teresa Kerry, and the Heinz family in Pennsylvania, with offices in Pittsburgh and Philadelphia, as well as offices on 3 continents. Reed Smith was retained by the Democratic National Committee to do, quote, political and legal work in 2004. I guess they were so excited by this work that somehow they thought they would engage in what they called a pro bono effort to get the Nader Romanelli candidacy off the ballot in Pennsylvania. This is rather remarkably touching for the firm to distract itself from defending high drug prices, from defending unsafe drugs on part of its corporate drug industry clients, to take that amount of time out of their sheer charitable impulse in order to make democracy work by ensuring compliance with the statutes of Pennsylvania on the part of the Nader Romanelli campaign. And so they unleashed their website, bragged, dozens of lawyers and paralegals, and some volunteer law students there for the summer in 2004, in a massive dragnet operation to get us off the ballot. And of course had a very, very convenient judiciary in Philadelphia to help them along. And they succeeded. As if that was not enough. As if it was not enough that they made very atrociously bad law. As if it was not enough that they will be forever tainted at law schools around the country to where they go to recruit young lawyers with this miscarriage of justice. They proceeded to push the envelope and asked the judge to assess costs on the Nader Romanelli candidacy. In person, Nader and Romanelli. And the judge basically said, "How much do you want?" And they said, "How about $81,000? Done." And we became the first defendants trying to defend ourselves and our rights to remain on the ballot in Pennsylvania, the first defendants in American legal history to be so assessed. Judge Collins once again misread the statute as he was tutored and chided by Justice Saylor. The word petitioner in the statute means the objector. It means Reed Smith. It does not mean Nader Romanelli. And the only person who can be assessed costs in the state of Pennsylvania is the unsuccessful objectors, not the candidates. And Judge Collins turned this right around and said it can be done to the candidate. Now what do you do with judges who regularly misread the statute? What you do with them is you impeach them, because this is a very grave issue. This is not a parking ticket. This is not a forged check. This is a slanderous judge who is either deliberately misreading the law, ignorantly misleading the law, or misleading the law out of sheer negligence and lassitude. All of them grounds for impeachment. Now, it's hard if you haven't been in our position to absorb the gravity of what was done and to absorb how this type of expulsion applied to Carl Romanelli 2 years later is going to spread in Pennsylvania and throughout the United States. Reed Smith has in effect perfected its role as the law firm King Kong Ballot Access Buster, with a sign that in effect says, we're open for more business. Because when you can serve a major party in a close election with another major party and expel a minor party candidate, you are going to be rewarded very well in subsequent considerations for business, or at least you're entitled to think that you're going to be rewarded in that manner. I suspect in the year 2008 that there are going to be tactics perfected here in Pennsylvania that will be used in states like Ohio, Florida, and Oregon, Illinois, Indiana, and elsewhere, wherever it is deemed necessary by one of the two major parties. This is not a two-party country. Should not be. Two parties do not own the voters in this country. They shouldn't be allowed to. Instead, what has happened is it has become a two-party country. It is a two-party elected dictatorship when it comes to excluding competition. If the two parties did what they do in the marketplace, they would be indicted for criminal violation of the antitrust laws. But unfortunately, they are in the political marketplace where they write the rules, they pass the Pennsylvania laws, they pass the laws that decide who gets on and who doesn't in 50 states. Canadians must be laughing at us when they see an electoral system where a person who comes in second in the popular vote becomes president, Bush in 2000. Do you know any other democratic society where you come in second and you can become president because of the electoral college? A system where the debate commission is a private corporation created by the two parties who determine which candidates are allowed to reach tens of millions of Americans by getting on the debate, and of course they make sure that no one has ever gotten on those debates except Ross Perot in 1992 because Clinton and Bush thought for different reasons it was tactically appropriate for Perot to be on. This is laughingstock material. We should be ashamed of ourselves. And I say this to Reed Smith. You're opening up the greatest confrontation on ballot access of any law firm in American history. So you better get ready. I say this to the Democratic Party. If you try to do this again and conspire with state Democratic committees and political consultants and phony 527s, you're not going to get a free ride on this cycle. And I say this to the members of Congress. It's time for one federal ballot access statute for all candidates running for federal office. Lacking that, the least the Pennsylvania legislature can do is to pass a bill that replaces the judge-by-judge, courtroom-by-courtroom deliberation, counting every vote in terms of whether they met certain ballot access criteria, every signatory on the petition, and put it into a nonpartisan statewide commission so that no party, major or minor, can decide with their partisan judges who's going to get on the ballot, who isn't, and what voters are going to be denied their free choice of candidate. There remains one additional problem, and that is the lack of public indignation, based on the lack of awareness. But even if there was awareness, there is an eerie reminder for those of us who know political legal history in our country of the way people were not particularly indignant when African American voters and candidates were driven off the ballot by partisan judges and major party interests in those communities. The kind of decisions that were made in the high state courts in the South in the 30s and 40s, they were deemed legal. But when you read them now, you're horrified by their callousness, their cruelty, their fascistic exclusion of people who wanted to vote and who wanted to run for office just because their color was black. And that's what we're going to see when it comes to ballot access for candidates. I sense that it's going to take a number of further defeats and denial of certiorari by the Supreme Court before they become more and more sensitized to this constitutional right of free speech, which is what running for office is. You speak, you petition, you assemble. It's the most consummate expression of the First Amendment right, that they will judicially defend it with as much vigor as they now destroy it. This will require more competition in our democratic processes. It will require more people to run for office, to challenge these obstructions around the country. And that's the only way they're going to be brought to the surface. It will require more local candidates, state candidates, and national candidates. And in so doing, we will see what we have been missing. Because historically, the great ideas that have animated social justice and driven it to some sort of success in our country have come from third parties. And aren't we glad that ballot access barriers were much lower in the 19th century than they are today, much less obstructive, because that allowed the Liberty Party, the Anti-Slavery Party, the Women's Right to Vote Party, the Labor Party, the Populist Party, the Farmer Party to get on the ballot. And aren't we glad that there were some voters in the 19th century who didn't say, well, we're going to go for the least worst on the issue of slavery between the Whig Party and the Democratic Party, who instead voted for the small party that led the fight, electorally speaking, against slavery? Aren't we glad that there were some voters who didn't try to figure out who the least worst was on the women's right to vote between the Democrats and the Republicans and supported the women's right to vote, or the women's suffrage party? Well, if we like that, then we should like it in the 21st century as well. Thank you very much.